Imagine a typical family, the Ivanovs. A Saturday trip to the store. In the parking lot, their car gets a minor scratch from another vehicle. No one is injured, and the drivers exchange contact information. It seems like a minor inconvenience. But what if I told you that this scratch is the first step toward their complete bankruptcy? In this video, we will dissect the mechanism that transforms any minor legal issue, from a car accident to a dispute with a neighbor, into a financial catastrophe for 95% of families. And I will show you why the system designed to protect you is, in reality, your chief adversary. A week later, the Ivanovs received not a repair bill, but a lawsuit. The driver of the second car, appearing perfectly healthy, is demanding 1,000,000 rubles for hidden neck injuries and profound emotional distress. Their insurance company states that this claim falls outside their coverage. Shock, disbelief. The Ivanovs realize they need a lawyer, and at that very moment, a clock starts ticking that can no longer be stopped. This isn't just bad luck. This is a classic tactic of financial attrition, where the goal of the lawsuit isn't to prove right, but to force the opponent to surrender under the weight of mounting expenses. And this is where the main myth shatters. In a system where everyone is supposedly equal before the law, being in the right turns out to be directly proportional to the thickness of one's wallet. An ordinary person who has spent a lifetime saving for their children's education is faced with a choice between justice and their family's financial survival. This isn't a glitch in the system, it's its fundamental design. Justice transforms from a basic right into an expensive subscription service. If you can't afford the premium tier, you only get the basic version, which is to say, practically nothing. We will uncover 3 hidden fees that no lawyer will tell you about. We'll examine 2 of the most dangerous scenarios, beyond car accidents, that lead families to ruin. And most importantly, we will assemble a 4-step protocol that will become your financial armor against such attacks. The first key mechanism of this trap isn't even the law itself. It's time. Time acts like a doomsday clock for your savings. Every day of delay, every new letter from lawyers, it's an arrow relentlessly moving towards financial zero. The Ivanovs find a lawyer. He quotes his rate, not for the case but by the hour. And at this moment they still don't realize that their main adversary in court isn't the other driver, but the relentless ticking clock on their own defender's desk. A lawyer's primary asset is their time, sold by the hour. Absolutely everything. A phone call, reviewing a document, writing a short letter, a trip to court. You pay for every single step. For the side with ample funds, this becomes an ideal weapon. They don't need to prove they are right. They simply need to drag out the process. Requesting new expert opinions, demanding new documents, postponing hearings for procedural reasons. Each such step means tens of thousands of rubles out of your pocket. On average, a qualified lawyer's hourly rate in a major city ranges from 10,000 to 25,000 rubles. A simple 15-minute phone call can cost 5,000 rubles from the family budget. One full day of a lawyer's work dedicated to your case can easily cost more than the average monthly salary of a Russian citizen. Here's what a real lawyer's bill might look like. Review of case materials, 4 hours. Phone conversation with opposing counsel, 30 minutes. Drafting a motion to postpone the hearing, 2 hours. For the Ivanovs, this means one thing. Even before their first court appearance, they already owe an amount equivalent to their total monthly income. They are paying for the process, not the outcome. It's like a taxi whose meter never stops. It ticks while the lawyer is stuck in traffic, sips coffee while studying your case, or simply thinks about it at night. You're not paying for the distance traveled, but for all the time the car is assigned to you. Now, a simple mental exercise. Recall your last serious dispute in a work chat, or a conflict with a neighbor over parking. Now imagine that every message you sent, every call you made, and every minute you spent contemplating a response cost you 1,000 rubles. How much would you have paid for yesterday? What sum would have accumulated over a week? Recognizing this simple fact is the first step toward understanding why the system works against you. This isn't a court, it's an endurance auction, where the prize is your financial future. The strategy of delaying is not aimed at winning in court. Its sole purpose is your financial and moral capitulation. At some point, you sit down with a calculator and realize, even if you win, you will have spent more on lawyers than the amount of the claim itself. And that's when you agree to an unfavorable settlement or simply give up. Victory goes not to the one who is right, but to the one with deeper pockets to pay for time. In military history, this is known as the Fabian strategy. The Roman dictator Fabius Maximus wore down Hannibal's army not through decisive battles, but through constant minor attacks and prolonging the war. The exact same thing happens in jurisprudence. You are defeated not by the strength of arguments, but by the methodical exhaustion of your resources. But hourly billing is merely the visible tip of the iceberg. It's the peak of a glacial mountain against which family budgets are shattered. There are hidden costs that lawyers often forget to mention during the initial meeting. And it is precisely these costs that deliver the decisive, often fatal blow to a family's financial well-being. The first of these hidden payments is expert evaluation. The court does not take anyone's word for it. It requires evidence certified by a specialist. In the Ivanov's case, this means two things. First, a medical expert opinion for the plaintiff, which must confirm his suffering. Second, a technical expert opinion to assess the damage to the car. Each of these costs anywhere from 50,000 to 200,000 rubles, and the party requesting the evaluation pays for it. This gives your opponent the power to literally assign you a bill. They can request 3 different expert evaluations, and you will be forced either to pay for your own or automatically lose. Moreover, these expert opinions can be quite unexpected. A handwriting analysis to prove the authenticity of a single signature, or even a linguistic analysis to interpret the meaning of one SMS message. Each one is a new blow to your budget. The second hidden expense is the justice tax, or court fees. Filing a lawsuit, an appeal, every official step requires payment of a state duty. These can be thousands and sometimes tens of thousands of rubles. Added to this are notary fees, certified mail, and the cost of copying hundreds of pages of case documents. These minor details, over a year of litigation, accumulate into a sum comparable to the cost of another expert evaluation. This is the classic death by 1,000 cuts effect. Each court fee, each notarized copy, it's a small, almost imperceptible cut to your budget. But over a year, hundreds accumulate, and you bleed money without even noticing the fatal wound. Let's introduce a hypothetical financial toxicity scale. The hourly rate of a lawyer, which we discussed, would be 7 out of 10. It's high, but at least predictable. However, the cost of expert evaluations is a solid 9 out of 10. Why? Because it's an expense completely beyond your control. Your opponent can literally assign you costs, and there's nothing you can do about it. It's a weapon handed to your enemy, and they use it against your bank account. But even this isn't the worst part. Here's a fact that delivers a true knockout punch. If you lose a lawsuit, in most cases, you will be obligated to pay not only your own expenses, but also all the legal fees of the winning side. Just imagine this scenario. You've already poured all your savings into your own defense. You've lost. And a month later, a second bill arrives, for the exact same amount, but from your opponent's lawyers. In the legal world, this is called the loser pays principle, or the reimbursement of legal costs. And this is the system's cruelest mechanism. It transforms losing in court from a financial problem into complete financial annihilation. You don't just lose, you pay for your loss twice. This system of expenses operates as a universal press, crushing any family caught in the gears of justice. But there are 3 situations, 3 minefields, where this press exerts its maximum destructive force, and a road traffic accident is just one of them. The second minefield is divorce. Here, pure emotions are layered onto the financial pressure. One spouse, driven by resentment, initiates a war of attrition. They dispute every minor detail. They demand unnecessary expert evaluations of property. Their goal isn't to gain more assets, but to force the other party to pay more to lawyers. Lawyers, seeing this, often play along, as each new escalation of conflict means new billable hours. Psychologists call this irrational escalation. The desire to punish a former partner becomes more important than one's own financial gain. A person is willing to spend 100,000 rubles on lawyers to win an asset worth 50,000. Logic switches off. Only emotions are at play, and the meter keeps ticking. The third field where family budgets explode is inheritance. Here, close relatives become enemies. Wills are contested, and evidence of the deceased's incapacity is sought. Such cases can drag on for years. During this time, the cost of legal services can easily eat up half of the inheritance itself, or even the entire sum. This phenomenon was perfectly described by Charles Dickens in his novel Bleak House. The probate case of Jarndyce and Jarndyce lasted so many generations that in the end, all the money went to pay the lawyers, and the heirs were left with nothing. This isn't just literature. It's an accurate description of reality for many families where only the lawyers win. Now let's briefly look at this through the eyes of an unscrupulous lawyer. For them, a client isn't a person in distress, but an asset. The longer the case drags on, the more conflicts it involves, the more valuable this asset becomes. Their objective isn't to solve the problem quickly, but to manage it for as long and as effectively as possible from a billing perspective. They aren't breaking the law. They are simply using the system's rules to their advantage, turning someone else's tragedy into their stable income. And finally, a scenario where your chances plummet to near zero. You're suing not an individual, but a corporation. They have an in-house team of lawyers for whom court cases are daily work. They can afford to delay the process indefinitely, file appeals, and take the case to the highest courts. For you, each such step means enormous expenses. For them, it's just work time already factored into their budget. It's like playing a video game where your opponent has infinite lives and health packs, while you have only one. Each round for you is immense stress and real costs. For them, it's just another level they complete according to a well-rehearsed strategy. It seems like a hopeless situation where the ordinary person always loses. But what if there are defense tools specifically designed to bypass this expensive system? Tools that you will rarely be told about during your first legal consultation. The first such tool is mediation. This is not a court. It involves negotiations with a neutral third party, a mediator. Their task isn't to find who is right or wrong, but to help the parties themselves find a solution that satisfies both. It is 10 times cheaper and faster. 1 or 2 sessions with a mediator can resolve an issue that would take years and millions of rubles in court. Why is this tool often kept quiet? Because lawyers earn significantly less from it than from a prolonged legal process. Statistics speak for themselves. Up to 80% of disputes submitted to mediation end in a settlement. This isn't magic, it's pure pragmatism. People with calculators in hand realize that a bad peace is better than a good war that is guaranteed to destroy their budget. The second tool is the power of a properly drafted document. A pretrial demand letter, written in precise legal language with references to specific articles of law, is not just a letter. It's a demonstration of your readiness for battle. It clearly shows the opponent that you know your rights, understand the legal prospects, and are not afraid to see it through. Such a demand is the legal equivalent of a warning shot fired into the air. You're not initiating a full-scale battle, but you're clearly signaling that you possess weapons, knowledge of the law, and are prepared to use them. Often, this alone is enough for the opposing party, after assessing the risks and future costs of their own lawyers, to come to the negotiating table themselves. The third path involves free options. In many large cities, there are state-run legal aid bureaus. They are established to assist those who cannot afford a lawyer. Additionally, some lawyers handle cases pro bono, meaning for free, as part of their social responsibility. Yes, getting access to them isn't easy. They are often overloaded, and there are long waiting lists. But it's a real chance to obtain qualified assistance if you have absolutely no money. It's important to understand that such services operate on a medical triage principle, similar to a field hospital. They prioritize the most critical cases: threats of eviction from one's only home, protection of children's rights, domestic violence. Your dispute over a car scratch is unlikely to be a high priority. However, it is crucial to be aware of this possibility. Now for a simple practical task. Right now, without closing this video, open a new browser tab. In the search bar, type 2 phrases: State Legal Aid Bureau, your city, and Free Legal Assistance, your city. Save these addresses and phone numbers in your notes. This will take you 30 seconds. Just 30 seconds. But in a critical moment, this knowledge could become your only lifeline. It's the first and simplest element of your financial armor. Do it. All these tools, mediation, a well-crafted demand letter, access to free assistance, can save your money and your nerves. They allow you to bypass the most expensive and dangerous traps of the system. But what should you do in the first few hours after an incident? When you're overwhelmed by anger, fear, and resentment. When any wrong word or action could become a fatal mistake that costs you everything. For that, there is a clear 4-step protocol, which we will now assemble. So, let's return to the Ivanovs in the parking lot. If they had known this protocol, their story might have been entirely different. These are 4 simple steps you should learn like a prayer. They protect not only your wallet but also your mental health. This is your personal algorithm for action in the first minutes of chaos. Step 1. Total documentation. From the very first second of any conflict, your phone is your greatest ally. Take photos, videos, audio recordings of conversations, screenshots of messages. Document absolutely everything. In court, words carry no weight. Only evidence does. The more you document, the less room your opponent has to maneuver. Remember the old adage, the faintest ink is better than the best memory. In moments of stress, your brain is an extremely unreliable witness. It forgets details, distorts facts. But a photograph with a date and time or an audio recording is an objective reality that cannot be disputed. Step 2. Controlled silence. Do not make verbal promises. Do not apologize if you are unsure of your fault. Do not engage in emotional arguments. Your only phrase should be, "I am prepared to discuss this within a legal framework." Recall the cliché from all Hollywood movies. Anything you say can and will be used against you. This isn't just a catchy phrase. It's a golden rule of self-preservation. Your emotional apologies can easily be interpreted by the court as a full admission of guilt, and threats as proof of your irrationality. Step 3. Pause before signing. Never sign anything on the spot. Do not agree to a settlement under pressure. Your first and foremost task is to obtain consultation. You don't necessarily need to hire an expensive lawyer. Sometimes a single paid consultation is enough to understand your real risks and prospects. It's like going to a doctor for a diagnosis before agreeing to complex surgery. A consultation is a legal MRI. It will reveal the true state of affairs. The cost of a consultation is the price of an accurate diagnosis that could save you millions on incorrect treatment. And step 4, the most crucial one. You should have a small legal fund. Let it be 30, 50, or 100,000 rubles. This is an amount that will allow you to pay for that initial consultation and the drafting of a proper demand letter without going into debt. Call it your personal legal security fund. This isn't just a rainy day fund. It's your strategic reserve that provides you with the most valuable resource at the start of a conflict: time. Time to avoid making panicked decisions under pressure and to find the right specialist, rather than just the first one you come across. The story of the Ivanovs, like thousands of others, is the result of what? Is it a systemic failure, where the law is simply imperfect and doesn't protect ordinary people? Or is it a cynical calculation, where the system is deliberately designed so that the strong and wealthy can always use it as a weapon against the weak? Write just one word in the comments: failure or calculation. Let's see which perspective dominates.